29 American states took the owner of Facebook and Instagram to court. They argued the products were built to hook children. In 2026, the case settled for billions of dollars with no admission of wrongdoing. The company also agreed to change the apps for teenagers. Daily time limits, pauses that interrupt the scroll, blocks at night once its rivals agree to do the same. A parent in New Zealand watching that might reasonably wonder what happens here. The answer is stranger, cheaper, and almost nobody knows it. New Zealand's response to online harm is not a lawsuit. It is a complaints line, and by law you have to use it first. Hold on to that one fact. It changes what you should do on a bad night. Let me show you the machine because it is genuinely unusual. In 2015, Parliament passed the Harmful Digital Communications Act. It came into force the following day, which tells you something about the mood. The Act does something most countries have never attempted. It writes down, in law, 10 things a digital message must not do. They are called the communication principles. A message should not disclose sensitive personal facts about someone. It should not be threatening or menacing or used to harass a person, grossly offensive, indecent, or carrying a false allegation, also on the list. Nothing that belittles a person for race, religion, gender, sexuality, or disability, and nothing that urges other people to pile on. 10 sentences. That is the whole standard. Now the part that surprises people. Breaking one of those principles does not send you straight to a judge. The Act created a role called the Approved Agency. It handed that job to a charity. The charity is Netsafe. Netsafe is not a court. It has no power to fine anyone. It cannot arrest a teenager or shut down an account. Read its statutory tools and they sound almost gentle. Advice, negotiation, mediation, persuasion. That is a law whose first weapon is a phone call, and you cannot skip it. Want a district court order about something posted online? You must complain to Netsafe first. The court is deliberately placed second in the queue. There is a threshold too, and it is high on purpose. The harm has to be serious emotional distress, not embarrassment, not annoyance, not a comment you disliked. For the court to step in, the breach must be serious, repeated, or clearly coming. So most of what happens under this law never reaches a courtroom at all. By 2021, Netsafe had received more than 14,000 complaints. Over the same period, around 500 people had been charged. Look at those two numbers together, and the design becomes obvious. The overwhelming majority of cases ended with someone being talked into taking a post down. There is a hard edge underneath, though. Deliberately posting something to cause a person serious emotional distress is a crime here. An individual can face 2 years in prison, or a fine of $50,000. A company can be fined $200,000. In 2022, Parliament added another offence, posting an intimate recording of someone without their consent. For a family, this is the practical shape of it. The photograph circulating around a school is not something you have to endure quietly. It is not a police matter first, and it is not a lawyer matter first. It is a complaint to a named agency, free, with a legal standard behind it. If that is useful to somebody you know, this is the episode to send them. But now for the limit, because it is the real lesson. Everything I have described protects one person from another person. A message, a poster, a named account, a specific piece of harm. Go back to those American states for a second. They were not arguing about a message at all. Their complaint was about how the product itself was built, the endless scroll, the notifications, what the feed learns to show a 14-year-old at midnight. Nobody sent that. it was designed. New Zealand's law has almost nothing to say about design. 10 principles aimed at what people post. No principle about what an algorithm chooses, so those teenage time limits and nighttime blocks came from a foreign courtroom. New Zealand parents will receive those changes as a kind of weather. They arrive because 29 attorneys general in another country had the leverage to demand them. That gap is not an oversight, it is a decade old. The law was written in 2015, when the worry was cyberbullying. The worry was a cruel classmate with a phone. That worry was correct, and the law it produced still works. Something else grew up beside it. Not a person being cruel, but a system being effective, and a complaints line, however good, cannot mediate with a recommendation engine. So New Zealand now has 2 problems wearing one name. For the first one, this country built something quietly excellent. 10 written principles, a free agency, and a court held in reserve. For the second, it has no equivalent, and the fix keeps arriving from somewhere else. Every parent here is left holding one question. When the harm has no sender, who exactly do you complain to?